Before we begin, a quick and important disclaimer. The content of this documentary is provided strictly for educational and entertainment purposes. It does not constitute legal advice, nor does it establish an attorney-client relationship between the creators and the viewers. The legal history and case studies discussed involve complex social, ethical, and jurisdictional shifts that vary significantly by state and era. Viewers are strongly encouraged to conduct their own due diligence and consult with a qualified legal professional regarding any personal legal matters or specific historical research. For the better part of the 20th century, there was a specific type of professional who was considered a social pariah, a man or woman who occupied the lowest rung of the American legal hierarchy. While corporate litigators were toasted in the boardrooms of Wall Street and criminal defense attorneys were romanticized as defenders of liberty, the divorce lawyer was whispered about in hushed, derogatory tones. They were the merchants of misery, the vultures of the domestic nest, and the engineers of social decay. In the eyes of the American public and the elite legal establishment, to be a matrimonial attorney was not just a career choice, it was a form of professional suicide. We often look at the modern billion-dollar industry of family law and see it as a standard pillar of the judicial system, but for decades, these practitioners operated in a shadow world of staged adultery, private detectives, and profound moral condemnation. They were the bombers, the shysters, and the homewreckers in three-piece suits. This is the untold story of how the American legal system created a class of professional outcasts, and why the stigma of the divorce lawyer was, for a long time, the most effective tool the state had to keep the American family under lock and key. To understand why this stigma was so pervasive, we have to look at the historical trends of the early 1900s. Today, we view divorce as a difficult personal transition, but in the pre-World War II era, it was viewed as a catastrophic failure of the social contract and an affront to the prevailing religious orthodoxy. Because marriage was legally viewed as a permanent sacrament rather than a civil contract that could be dissolved by mutual consent, the law required a guilty party. You could not simply decide to leave. You had to prove that your spouse had committed a grievous sin, usually adultery, extreme cruelty, or desertion. This created a legal environment where every divorce was a battle of fault. And where there is a battle of fault, there is a need for a specialist who is willing to get their hands dirty. The elite white shoe law firms of the era, the prestigious institutions that handled the affairs of the Rockefellers and the Morgans, wouldn't touch a divorce case with a 10-foot pole. They viewed family law as gutter law. They believed that a gentleman lawyer should deal with the clean intellectual disputes of contracts and torts, not the messy, emotional, and often filthy details of a broken bedroom. This left a vacuum that was filled by solo practitioners and small firms, often made up of immigrants or first-generation Americans who were excluded from the high society firms. Thus, the stigma was layered with classism and xenophobia. The divorce mill lawyer became a trope in American media. A man operating out of a cramped, cigarette smoke-filled office above a deli, willing to suborn perjury for a few $100s. Case studies from the 1930s and 40s reveal the lengths to which these lawyers had to go to serve their clients. Because mutual consent was not a legal ground for divorce, lawyers were often forced to participate in what became known as collusive divorce. This was a systemic open secret where the husband and wife would agree to stage a scene of adultery. The lawyer would hire a professional correspondent, usually a young woman paid to be found in a hotel room with the husband, and a private investigator to discover them. The investigator would then testify in court, the lawyer would present the evidence, and the judge, often winking at the obvious fabrication, would grant the decree. While this allowed couples to escape miserable marriages, it branded the lawyers as dishonest manipulators of the law. They weren't seen as advocates for the unhappy. They were seen as the architects of a grand national lie. This historical trend of viewing the divorce lawyer as a liar for hire was reinforced by the American Bar Association's early ethical canons. For a long period, it was considered unprofessional to even specialize in divorce. The logic was that a good lawyer should be working to preserve the moral fabric of society, and by facilitating the dissolution of marriages, these lawyers were actively tearing that fabric. This created a potential outcome where a lawyer who became too successful in the matrimonial field would find themselves barred from judicial appointments or social clubs. They were the people you called in the middle of the night when your life was falling apart, but you wouldn't dare invite them to dinner the next evening. The stigma was further exacerbated by the migratory divorce phenomenon. In states like New York, where the only ground for divorce was adultery, wealthy citizens would travel to divorce colonies in Nevada or Idaho, where the laws were more relaxed. The lawyers who set up shop in cities like Reno were viewed by the rest of the country as mercenaries. They were accused of commodifying the end of the American family. In 1931, Nevada lowered its residency requirement to just 6 weeks, turning divorce into a high-volume industry. The lawyers there weren't just practicing law, they were running a factory. The national press portrayed these practitioners as fixers, who sold freedom to the highest bidder, further cementing the idea that a divorce lawyer was someone who circumvented the spirit of the law for profit. Consider the psychological and social toll this took on the practitioners themselves. For decades, a family law attorney had to walk a tightrope. If they were too aggressive, they were bombers who destroyed any hope of an amicable settlement to inflate their fees. If they were too conciliatory, they were weak and failing their clients. They were the only legal professionals who were routinely blamed for the very existence of the problem they were hired to solve. People didn't blame doctors for cancer, and they didn't blame criminal lawyers for the existence of crime, but they absolutely blamed divorce lawyers for the rising divorce rate. This was a classic case of shooting the messenger. Society was changing. Industrialization, the rise of women's rights, and shifting moral codes were making the traditional, lifelong marriage model unsustainable for many, but it was easier to point the finger at the greedy lawyer than to confront the changing reality of the American home. By the 1950s, the golden age of the nuclear family, the stigma reached a fever pitch. In the post-war era, the family was the front line of the Cold War. Stability at home was equated with national security. To be a divorce lawyer in the 1950s was to be perceived as an agent of subversion. When we look at the data from that era, we see a massive discrepancy between the number of people who desperately wanted out of their marriages and the social standing of the professionals who could help them. It was a market defined by high demand and low status, a volatile mix that resulted in high fees, back alley deals, and a reputation for sleaze that would take decades to even begin to wash away. In this deep dive, we are going to unpack exactly how the stigma was constructed, the specific legal structures that force lawyers into unethical territory just to get results for their clients, and how the transition to no-fault divorce in the 1970s didn't just change the law, it fundamentally threatened the identity of the legal profession. This isn't just a history of law, it's a history of how America deals with its deepest shames and its most painful transitions. By understanding the historical stigma of the divorce lawyer, we can finally see why our modern family court system is still haunted by the ghosts of its gutter law past. We are going to examine the case files that were never meant to be public, the legislative battles that were fought in the shadows, and the step-by-step evolution of a profession that moved from the fringes of society to the very center of the American experience. This is part 1 of a journey into the dark heart of domestic litigation, exploring why the person you hate the most is often the only one who can set you free. To truly understand the weight of the stigma, we have to look at the legal architecture that governed the United States for over a century. Imagine it is not 2026, but 1945. You are a successful architect named Arthur living in a brownstone in New York City. You and your wife have realized that you are fundamentally incompatible. There is no abuse, no hidden gambling debt, and no third party. You have simply grown apart. In 2026, this is a standard no-fault filing. In 1945, you are legally trapped. The law does not recognize your unhappiness as a valid reason to end a contract sanctioned by both the state and the church. For Arthur to get a divorce, he must prove that his wife committed a crime against the marriage, or she must prove it against him. This was the era of the fault-based system, and it was the primary reason the divorce lawyer was viewed as a moral scavenger. The legal requirements of the time created a paradoxical situation where the only way to follow the law was to break its spirit. Because the grounds for divorce were so narrow, limited primarily to adultery, extreme physical cruelty, or willful desertion, lawyers were forced to become directors of elaborate, fictional plays. This gave rise to the professional correspondent. These were individuals, often young women or men looking for quick cash, who were hired to be caught in compromising positions. A typical case study of this era involves a divorce lawyer coordinating with the private investigator to set up a raid. The lawyer would instruct the husband to check into a hotel room with the hired correspondent. At a prearranged time, the private investigator, often accompanied by the wife and a photographer, would burst into the room. The photographer would capture a single image of the husband in his shirt sleeves and the correspondent in her slip. This was the evidence needed to satisfy the court. The divorce lawyer was the one who orchestrated this entire charade. They were the ones who kept the professional correspondence on speed dial. They were the ones who coached the witnesses on exactly what to say so that their testimony wouldn't look too rehearsed, even though everyone in the courtroom knew it was a total fabrication. This led to a historical trend where the legal profession itself viewed matrimonial practitioners as sub-attorneys. They weren't litigating fine points of constitutional law, they were managing a production of state-sanctioned perjury. From the perspective of the American Bar Association at the time, these lawyers were not just representing clients, they were polluting the integrity of the judicial system. This created a potential outcome where a divorce lawyer, no matter how skilled or empathetic, was permanently barred from the inner circles of legal power. Furthermore, the data from this period suggests that the stigma was reinforced by the extreme financial disparity in who could access these services. Because these staged divorces were expensive, requiring the hiring of investigators, correspondents, and the payment of significant legal fees, the divorce lawyer was often seen as a fixer for the wealthy. They were the ones who helped the elites bypass the moral laws that the rest of the country had to live by. In the eyes of the public, the divorce lawyer was a mercenary who sold an escape hatch to the rich while the poor were left to suffer in broken, sometimes even violent, homes. This contributed to a narrative of the lawyer as a corrupting influence on the American family unit, someone who made a living by facilitating the whims of the bored and the wealthy. The physical reality of the divorce lawyer's daily life also contributed to the low-status perception. While corporate lawyers worked in gleaming towers, the matrimonial specialist was often found in the courthouse hallways or in cramped offices near the municipal buildings. They were dealing with the rawest, most volatile human emotions every single day. They saw the bruises, the broken furniture, and the shattered lives that the rest of society wanted to ignore. Because they dealt with what was considered the filth of human relationships, they were seen as being covered in that same filth. There was a pervasive idea that you could not handle such messy cases without becoming messy yourself. Consider the case study of New York's restrictive laws versus Nevada's residency requirements. This created the infamous Reno divorce industry. Lawyers in Reno would wait at the train station for women arriving from the East Coast. These women, often referred to as six-weekers, had to live in Nevada for a short period to establish residency before they could file for a quick divorce. The lawyers who specialized in this were seen as even lower than the urban fixers. They were viewed as vultures preying on the desperation of women, who were willing to uproot their lives just to escape a marriage. The national media portrayed these Reno lawyers as the ultimate examples of legal degeneracy. They were the face of an industry that turned the sanctity of marriage into a high-volume, assembly line business. This historical trend of viewing the divorce lawyer as a facilitator of fraud had a chilling effect on the development of family law as a respected field. It meant that the best and brightest legal minds often avoided the practice entirely. If you were a top graduate from Harvard or Yale in the 1950s, you went into tax law or corporate litigation. To choose divorce law was to tell the world that you weren't good enough for real law. This created a self-fulfilling prophecy. Because the field was stigmatized, it was often left to those who were willing to operate in the shadows, which in turn reinforced the stigma. Even the language used in the courtroom during this era was designed to humiliate the parties involved, and the lawyer was the one who had to deliver that humiliation. A lawyer had to stand up in front of a judge and a gallery of spectators and detail every perceived failing of their client's spouse. They had to use words like lewd, lascivious, and abandoned. They were the mouthpieces for the most intimate and painful accusations. In a society that valued privacy and decorum, the person who made their living by dragging private laundry into the public square was never going to be a hero. They were a necessary evil at best, and a social pariah at worst. By the time we reached the mid-1960s, the pressure cooker of the fault-based system was beginning to explode. The disconnect between the reality of American lives and the rigid, punitive nature of divorce law was too great to ignore. The lawyers who had spent decades operating in the shadows of the fault system were about to face a massive shift. But as we will see, the move toward reform didn't instantly wash away the grime of the past. In fact, for many, the arrival of new laws only made the role of the divorce lawyer even more controversial. The question was no longer just about whether they were helping people lie. It was about whether they were now making it too easy for the American family to disappear entirely. If the 1940s and 50s were about the lawyer as a secret fixer, the 1960s and 70s were about the lawyer as a social revolutionary, or, depending on who you asked, a social assassin. The laws began to change, a new kind of legal war was being declared, and the tactics were about to get much more aggressive. The era of the bomber was about to begin, and with it, the stigma of the divorce lawyer would mutate into something even more fearsome. But how did a simple change in the law lead to the birth of the most aggressive litigators in history? And why did the very people who fought for these changes end up fearing the lawyers they helped create? We'll dive into the rise of the high conflict specialist and the invention of the scorched earth policy in the next part. Before we begin, a quick and important disclaimer. The content of this documentary is provided strictly for educational and entertainment purposes. It does not constitute legal advice, nor does it establish an attorney-client relationship between the creators and the viewers. The legal history and case studies discussed involve complex social, ethical, and jurisdictional shifts that vary significantly by state and era. Viewers are strongly encouraged to conduct their own due diligence and consult with a qualified legal professional regarding any personal legal matters or specific historical research. As we move into the 1960s and 1970s, the United States underwent a seismic shift that would forever change the face of the legal profession. For decades, the divorce lawyer was the shyster in the shadows, the man who managed the hotel room charades and the staged adultery. But as the cultural revolution of the 60s took hold, a new legal framework emerged that was supposed to clean up the industry. This was the era of the no-fault revolution. In 1969, California Governor Ronald Reagan signed the Family Law Act, which theoretically ended the need for a guilty party. The goal was simple: reduce the bitterness, eliminate the perjury, and allow couples to part ways with dignity. However, the potential outcomes of this legislation were far from the peaceful utopia the reformers imagined. Instead of disappearing, the stigma of the divorce lawyer simply mutated into something much more dangerous. The lawyer was no longer just a liar, they became a bomber. Imagine it is 1975. We will look at a character named Robert, a mid-level executive at a manufacturing firm in Ohio. Robert believes his divorce will be a quiet, administrative affair. He and his wife Susan have simply drifted apart. He expects the new no-fault laws to act like a civil contract dissolution. But Susan, fearing for her financial future in an era where women were still fighting for equal credit and professional footing, hires a specialist who has embraced the scorched earth policy. Robert soon discovers that while the law no longer cares about who cheated on whom, it cares deeply about every cent in his 401k, the valuation of his stock options, and the precise psychological fitness of his parenting. The lawyer he faces isn't a back-alley fixer. He is a high-priced mercenary who uses the legal system to wage total war. The historical trends of this era show a massive explosion in the divorce rate, which doubled between 1960 and 1980. This created a gold rush for the legal profession. As the volume of cases grew, the competition among attorneys intensified. To stand out in a crowded market, lawyers began to adopt more aggressive personas. The stigma shifted from being a low-status practitioner of gutter law to being a high-status, high-conflict destroyer of families. The public perception was that these lawyers were now actively encouraging conflict to drive up billable hours. In the fault-based era, the lawyer's job was to prove a single lie. In the no-fault era, the lawyer's job was to maximize the leverage in a financial and emotional negotiation that could last for years. The scorched earth strategy became a step-by-step masterclass in psychological and financial exhaustion. Step 1 was the surprise filing. This involved serving the spouse with divorce papers in a public or humiliating way, at their office, in front of colleagues, or during a family event. This was designed to create an immediate state of shock and reactive panic. Step 2 was the financial freeze. Lawyers would use temporary orders to freeze all joint bank accounts and credit cards, effectively starving the other party into submission before the first hearing even took place. Step 3 was the discovery avalanche. This involved sending hundreds of pages of requests for documents, demanding every receipt, every tax return, and every diary entry from the last decade. The point wasn't just to find assets. It was to make the process so expensive and exhausting that the other spouse would settle for pennies on the dollar just to make it stop. Consider the case studies of the late 1970s involving the emergence of the forensic accountant. Before this, divorce was about morality, now it was about math. Matrimonial lawyers began partnering with specialized accountants to dig through corporate ledgers and hidden offshore accounts. While this was a legitimate legal service, the public saw it as a form of legalized extortion. The divorce lawyer was perceived as the person who would find a way to take a man's business or a woman's inheritance and split it down the middle, regardless of who had worked for it. This was the birth of the divorce industrial complex. The lawyers, the accountants, the private investigators, and the newly emerging child psychologists were all seen as vultures picking over the carcass of the American home. The weaponization of custody was perhaps the most significant contributor to the new stigma. Under the old fault system, the tender years doctrine almost always gave custody to the mother. But as gender roles shifted and the best interests of the child standard was adopted, custody became a wide-open battlefield. Lawyers realized that the person who could paint the other as an unstable or unfit parent gained massive leverage in financial negotiations. This led to the rise of the character assassination deposition. Imagine a lawyer sitting across from a father in 1978 and asking him under oath to recount every time he had a glass of wine, every time he stayed late at work, and every time he lost his temper. These transcripts would then be used to argue that he was an absentee or dangerous parent. The lawyer was the one sharpening the knife for these attacks, and the public revulsion toward this tactic was immense. Data from the American Bar Association during this period shows a significant rise in ethical complaints against matrimonial attorneys. Most of these complaints weren't about losing cases, they were about the tactics used to win them. The public felt that the lawyers were the ones preventing settlements. If a husband and wife wanted to be reasonable, their lawyers would often advise them that being reasonable was a sign of weakness that would cost them thousands of dollars. The lawyer was seen as the person who whispered in your ear that your spouse was your mortal enemy. This reinforced the idea that the divorce lawyer wasn't a problem solver, but a problem creator. The social standing of the divorce lawyer also suffered because of the 1977 Supreme Court decision in Bates v. State Bar of Arizona, which allowed lawyers to advertise. For the first time, divorce lawyers were on television, in newspapers, and on billboards. They used taglines like aggressive representation or don't lose what you worked for. To a public that still viewed divorce as a tragedy, seeing it marketed like a discount tire sale was deeply offensive. It made the profession look predatory. The stigma of the shyster was replaced by the stigma of the ambulance chaser of the heart. These lawyers were seen as people who didn't just wait for marriages to fail, but who actively marketed the idea that life might be better if you just walked away and took half the assets with you. As we moved into the 1980s, this tension reached a breaking point. The no-fault revolution had failed to make divorce civil. If anything, it had made it more expensive and more litigious. The lawyers who specialized in this field were now some of the wealthiest in the country, but they were also the most hated. They were the ones who drove the Ferraris bought with the college funds of the children whose families they had just dismantled. This was the era of the high-stakes celebrity divorce, where the tactics of the bomber were put on full display for the entire nation to see. But as the 1980s dawned, a new and even more controversial element was about to be introduced into the mix. It wasn't just about money anymore, and it wasn't just about who got the house. The legal system was about to find a way to put a price tag on the very future of the human beings involved. The rise of the child support guidelines and the permanent alimony battles were about to turn the divorce lawyer from a temporary combatant into a lifelong overseer of their client's finances. How did the law turn a one-time breakup into a 20-year financial sentence? And why did the very lawyers who pioneered these rules eventually become the targets of the most intense public anger in American history? We will look at the rise of the fathers' rights movement and the systemic backlash against the divorce industry in the next part. Before we begin, a quick and important disclaimer. The content of this documentary is provided strictly for educational and entertainment purposes. It does not constitute legal advice, nor does it establish an attorney-client relationship between the creators and the viewers. The legal history and case studies discussed involve complex social, ethical, and jurisdictional shifts that vary significantly by state and era. Viewers are strongly encouraged to conduct their own due diligence and consult with a qualified legal professional regarding any personal legal matters or specific historical research. The transition from the late 1970s into the 1980s marked a professional turning point where the divorce lawyer shifted from being a social pariah to being viewed as a systemic villain. If the previous decades were defined by the lawyer as a creator of fake drama to satisfy restrictive laws, the 1980s introduced a new, more clinical form of hostility. This was the era of the codification of conflict. In 1984, the United States passed the Child Support Enforcement Amendments, which required states to establish numeric guidelines for child support. Suddenly, the divorce lawyer was no longer just arguing about who was a better person. They were the enforcers of a cold mathematical formula that would dictate the financial survival of two separate households for the next 2 decades. This transformed the attorney into a human calculator of misery. Imagine if you are David, a software engineer in 1992. David represents the emerging middle class of the digital age. He has a solid salary, a suburban home, and 2 children. When his marriage ends, he walks into a wood-paneled office expecting a fair division of what he has built. Instead, he is met with the step-by-step financial dismantling. His wife's lawyer presents a spreadsheet. Step 1 is the calculation of gross income, including potential bonuses David hasn't even earned yet. Step 2 is the application of the state's rigid percentage-based formula, which in the early 90s rarely accounted for the actual time the children spent with the father. Step 3 is the garnishment of wages. To David, the lawyer across the table isn't just an advocate for his ex-wife. They are a representative of an overreaching state apparatus designed to turn him into a walking ATM. This case study reflects the broader historical trend where the divorce lawyer became the primary target for the frustrations of the growing fathers' rights movement. The stigma in the 1990s took on a gendered and political edge that hadn't existed before. Organizations began to form across the United States, protesting at courthouses and claiming that the legal system was rigged. The divorce lawyer was seen as the rigger, because the majority of custody awards still went to mothers during this period, and child support was primarily paid by fathers. The matrimonial attorney was branded as an architect of fatherless homes. This was the era of the silver bullet strategy, a term that became a staple in the lexicon of legal stigma. The silver bullet was a tactic where a lawyer would allegedly encourage a client to make a strategic allegation of domestic violence or child abuse right at the start of the case. This move would trigger an immediate ex parte restraining order, removing the other parent from the home and cutting off contact with the children before a single piece of evidence was heard in a full trial. While these laws were designed to protect legitimate victims, the public perception, rightly or wrongly, was that lawyers were using them as high-stakes leverage. The potential outcomes of such a tactic were devastating. A parent could lose their home, their reputation, and their children in a single afternoon. The lawyer who filed that paperwork was no longer seen as a professional doing their job. They were seen as a social assassin who used the law to commit character murder. Data from the 1990s shows a sharp increase in the number of high-conflict cases that dragged on for 3 to 5 years. The reason for this longevity was often the new complexity of assets. This was the decade of the executive compensation battle. Lawyers had to learn how to value unvested stock options, intellectual property, and professional degrees. In the famous case study of O'Brien v. O'Brien, the court ruled that a medical license could be considered marital property subject to valuation and distribution. This meant that a divorce lawyer was now tasked with putting a dollar amount on a person's future career. To the public, this felt like a violation of the individual. It looked as though lawyers were trying to own a piece of a person's soul and labor long after the marriage was over. The stigma of greed was no longer just about high hourly rates. It was about the lawyer's perceived desire to commodify every aspect of human achievement. The 1980s and 90s also saw the rise of the celebrity divorce specialist, which acted as a megaphone for the industry's worst stereotypes. When the public read about the massive settlements in the divorces of Donald Trump or Steven Spielberg, they saw lawyers like Raoul Felder or Marvin Mitchelson as the real winners. These attorneys became household names, often appearing on talk shows to discuss the intimate details of their high-profile cases. They dressed in expensive suits, drove luxury cars, and spoke about divorce as if it were a high-stakes sport. This created a profound disconnect. While the average American was experiencing the trauma of family dissolution as a financial and emotional catastrophe, the leaders of the matrimonial bar were seen celebrating it as a path to fame and fortune. This reinforced the historical trend of the divorce lawyer as a vampire, feeding off the blood of broken hearts and the gold of broken homes. We must also look at the psychological warfare that became standardized in this era. Lawyers began hiring private investigators not just to find adultery, which was less relevant under no-fault laws, but to find dirt that could be used in custody evaluations. Step 1. Follow the spouse to see if they were drinking at a bar. Step 2. Interview neighbors to see if the spouse ever yelled at the kids. Step 3. Use this information to intimidate the spouse during a deposition. The lawyer was the one directing this surveillance. In the eyes of the public, this transformed the legal process into a state-sponsored stalking campaign. The divorce lawyer wasn't just representing a client. They were managing a private intelligence operation. By the late 1990s, the backlash reached the halls of state legislatures. The stigma had become so toxic that a movement for collaborative law began to take root. This was a direct response to the bomber era. Lawyers began to market themselves as peacemakers, who would only take a case if both parties agreed not to go to court. However, even this attempt at rebranding was met with skepticism. Critics argued that this was just another way for lawyers to charge high fees while doing less work. The stigma was so deeply ingrained that even when lawyers tried to be the good guys, the public suspected a hidden agenda. As we approached the turn of the millennium, a new force was about to enter the fray, one that would strip away the lawyer's control over the narrative: the internet. The birth of online forums and public review sites meant that for the first time in history, the victims of the divorce industry could talk to each other in real time. The quiet whispers of the 1950s were about to become a global shout. The divorce lawyer was about to face a world where their every move was tracked, rated, and scrutinized by a digital mob. But as the tools of the trade shifted from paper files to digital databases, the nature of the conflict was about to become even more invasive. How did the digital age turn your private emails and social media posts into the ultimate legal weapon? And why did the arrival of the 2000s make the divorce lawyer more feared than ever before? We will examine the birth of digital surveillance and the e-divorce era in the next part. Before we begin, a quick and important disclaimer. The content of this documentary is provided strictly for educational and entertainment purposes. It does not constitute legal advice, nor does it establish an attorney-client relationship between the creators and the viewers. The legal history and case studies discussed involve complex social, ethical, and jurisdictional shifts that vary significantly by state and era. Viewers are strongly encouraged to conduct their own due diligence and consult with a qualified legal professional regarding any personal legal matters or specific historical research. The arrival of the year 2000 didn't just bring a new millennium, it brought the end of the secret. For over a century, the divorce lawyer's greatest obstacle, and their greatest tool, was the difficulty of proving what happened behind closed doors. But as the United States transitioned into the digital age, those doors didn't just open. They were unhinged and digitized. This era marked the birth of the digital predator stigma. If the 1980s lawyer was a bomber, the 2000s lawyer was a hacker of the human soul. They stopped looking for lipstick on collars and started looking for metadata in image files. This shift fundamentally changed how the American public viewed the profession, transforming the attorney from a legal advocate into a high-tech voyeur who specialized in the systematic stripping of privacy. Imagine if you are Jennifer, a schoolteacher in 2008. Jennifer is going through a relatively standard divorce. She believes her private life is her own, especially since she lives in a no-fault state. But Jennifer has a MySpace page and a burgeoning Facebook account. One night, while the children are with their father, she goes to a birthday party, has 2 glasses of wine, and poses for a silly photo with a group of friends. She thinks nothing of it. However, her husband's lawyer has spent the last month conducting a social media sweep. This is a step-by-step process of digital infiltration. Step 1. Identify every platform the spouse uses. Step 2. Use a third party or a fake profile to bypass privacy settings. Step 3. Harvest every image, comment, and check-in to build a narrative of parental instability. In court, Jennifer's lawyer has to watch as that single photo is blown up on a screen to suggest she prioritizes partying over her children. The lawyer who presented that photo wasn't seen as doing a good job. They were seen as a digital stalker who weaponized a woman's joy against her motherhood. The historical trends of the early 2000s show that as technology evolved, so did the legal rules of engagement. In 2006, the United States Supreme Court approved amendments to the Federal Rules of Civil Procedure that specifically addressed electronic discovery or e-discovery. While these rules were intended for massive corporate lawsuits, they were immediately adopted as a lethal weapon in family law. Suddenly, a divorce lawyer could demand access to a spouse's hard drive, their browser history, and every text message they had sent in the last 5 years. This created a potential outcome where a person's entire digital existence was put under a microscope. The stigma of the divorce lawyer mutated. They were no longer just greedy, they were invasive. They were the people who would read your deleted emails from 2004 to find a single sentence that could be twisted to make you look like a liar. Consider the case study of Mark, a small business owner in 2005. Mark was an early adopter of the BlackBerry. He used it for everything: client meetings, bank transfers, and private venting to his brother about his crumbling marriage. During the discovery phase of his divorce, his wife's attorney issued a subpoena for his service provider records and a forensic image of his device. The lawyer then hired a digital forensic specialist to reconstruct deleted messages. Step 1. Create a bit-by-bit copy of the device. Step 2. Use specialized software to bypass encryption. Step 3. Run keyword searches for terms like cash, transfer, or the names of any suspected romantic interests. The result was a 500-page log of Mark's most private thoughts and financial movements. The public perception of this tactic was one of deep revulsion. The divorce lawyer was seen as the person who killed the idea of a private thought. They turned the devices we loved into spies in our pockets. This era also saw the rise of the GPS tracking controversy. In the early 2000s, GPS technology became affordable for the general public. Some aggressive divorce lawyers began advising their clients, or the private investigators they hired, to surreptitiously attach GPS trackers to the family car. This was a legal gray area at the time, but the moral standing was clear in the eyes of the public. It was stalking. When these cases hit the news, the divorce lawyer was portrayed as the mastermind behind a domestic surveillance state. They were the ones who knew exactly where you were at 2 p.m. on a Tuesday, and they were ready to use that information to take your house or your kids. This solidified the image of the matrimonial attorney as someone who operated without a moral compass, using whatever technology was available to crush the opposing party. The stigma was further amplified by the democratization of the internet through rating and review sites. In 2007, the site Avu was launched, allowing clients to publicly rate their lawyers. For the first time, the victims of the divorce industry had a platform to fight back. If you look at the historical data of lawyer ratings from this period, family law practitioners consistently received the lowest scores and the most vitriolic comments. They were called heartless, money-grubbing, and toxic. This created a feedback loop. The more the public read these reviews, the more they expected their own divorce lawyer to be a villain. It became a self-fulfilling prophecy where the lawyer, fearing for their reputation, became even more defensive and aggressive, which in turn led to more negative reviews. We must also examine the financial surveillance of the mid-2000s. With the rise of online banking and early digital payment platforms like PayPal, hiding assets became a high-tech game of cat and mouse. Divorce lawyers began to specialize in following the digital breadcrumbs. They would look at Netflix subscriptions to see if a spouse was paying for an account in another city, or they would track Amazon purchase histories to prove a spouse was buying gifts for someone else. Step 1. Obtain the login credentials or subpoena the records. Step 2. Cross-reference spending patterns with known income. Step 3. Present the lifestyle analysis to the court to demand higher alimony. To the average American, this felt like a gross overreach. The lawyer was no longer just an advocate. They were a forensic auditor of your every cup of coffee and every book you bought. By 2010, the e-divorce era had completely stripped the profession of its remaining dignity. The divorce lawyer was now a permanent fixture in the cultural imagination as a cold-blooded technocrat who thrived on the data of human failure. But as the world moved into the 2010s, a new phenomenon began to emerge that would challenge the very necessity of the high-priced lawyer. The DIY divorce and the rise of automated legal apps promised to cut the vultures out of the process entirely. However, as the lawyers felt their grip on the industry slipping, they didn't just walk away. They pivoted. They found a new demographic to target, one with more assets and more to lose than any generation before them. This was the birth of the Gray Divorce movement, where the stakes were no longer about young children, but about multi-million-dollar retirement accounts and the inheritance of the next generation. How did the divorce lawyer reinvent themselves to target the elderly? And why did this new frontier lead to some of the most heartless legal battles in American history? We will look at the rise of the silver vultures and the battle for the boomer inheritance in the next part. Before we begin, a quick and important disclaimer. The content of this documentary is provided strictly for educational and entertainment purposes. It does not constitute legal advice, nor does it establish an attorney-client relationship between the creators and the viewers. The legal history and case studies discussed involve complex social, ethical, and jurisdictional shifts that vary significantly by state and era. Viewers are strongly encouraged to conduct their own due diligence and consult with a qualified legal professional regarding any personal legal matters or specific historical research. By the early 2010s, the archetype of the divorce lawyer underwent a final chilling transformation. The digital age had already stripped away the privacy of the bedroom, but the aging of the largest wealth-holding generation in United States history created a new theater of war. This was the birth of the gray divorce phenomenon. According to historical trends and data from the Pew Research Center, the divorce rate for adults over the age of 50 doubled between 1990 and 2015. For those over 65, it tripled. This wasn't just a statistical anomaly. It was a massive transfer of wealth that required a new kind of legal specialist. The public, watching as 40-year marriages dissolved in the twilight of life, coined a new derogatory term for these practitioners, the silver vultures. Imagine if you are George, a 70-year-old retired civil engineer in 2026. George and his wife Susan have been married for 44 years. They have 3 adult children, 5 grandchildren, and a combined retirement portfolio worth millions, including a paid-off home in a high-value coastal suburb. When the marriage hits an irreconcilable impasse, George enters the legal system thinking it will be a respectful division of their life's work. Instead, he encounters the step-by-step late-life liquidation. The lawyers involved aren't arguing about who gets the minivan. They are conducting a forensic autopsy of a 4-decade-old financial organism. The first step in this specialized legal playbook is the actuarial attack. In a standard divorce, assets are split and everyone moves on. In a gray divorce, the lawyer's primary goal is to secure the client's survival for the next 25 years of non-working life. This involves hiring pension evaluators to determine the present value of future Social Security benefits and complex retirement accounts. The divorce lawyer becomes a hunter of QDROs, qualified domestic relations orders. This is a highly technical legal instrument that allows a retirement plan to be divided and paid to someone other than the participant. To the adult children watching their parents' inheritance being sliced away by legal fees and court-ordered splits, the lawyer isn't a protector of their mother or father. They are a tax on the family's legacy. The stigma of the silver vulture is rooted in the perception that these lawyers are grave robbers of the American dream. The historical trend shows that while younger couples fight over the future, older couples fight over the past. Case studies from the mid-2010s reveal a disturbing escalation in the weaponization of health. Step 1. A lawyer identifies that the opposing spouse has early-stage cognitive decline or a chronic health condition. Step 2. They use this information to argue for a disproportionate share of the assets, claiming the spouse is incapable of managing their own finances or will require extraordinary care that justifies a larger settlement. Step 3. The healthy spouse is left with a fraction of the retirement they built, while the lawyer takes a significant percentage in billable hours. This tactic, while legally permissible in some jurisdictions to ensure support, is viewed by the public as the ultimate act of heartlessness. Data from the American Academy of Matrimonial Lawyers suggests that gray divorces are significantly more expensive and take longer to resolve than any other demographic. This is because the assets, real estate, pensions, heirlooms, and investments are deeply intertwined. The divorce lawyer in this era is seen as the person who forces the sale of the family home, where the grandchildren were supposed to spend their summers. The lawyer is the one who insists on an appraisal of the jewelry that was meant to be passed down. This created a potential outcome where the lawyer was no longer just a homewrecker, but a legacy destroyer. In the eyes of the public, they were the ones who ensured that the wealth accumulated by the greatest generation and the boomers would be funneled into the legal industry rather than the next generation. Furthermore, the 2010s saw a massive societal backlash against permanent alimony. In several states such as Florida and Massachusetts, advocacy groups, often led by second wives or adult children, began lobbying for the total elimination of alimony for life. They argued that it was a relic of a bygone era, and that lawyers were the ones keeping it alive to ensure a steady stream of litigation. The divorce lawyer was branded as the defender of the parasitic spouse. The narrative was that lawyers would encourage their clients never to remarry or seek employment, just to keep the alimony checks, and the legal disputes over them, flowing indefinitely. The lawyer was seen as the puppet master behind a lifelong financial sentence. Consider the psychological impact on the practitioners. Unlike the bombers of the 80s who thrived on aggression, the silver vultures of the 2020s often present themselves as protection specialists. They use a refined, clinical language, speaking of asset protection and long-term care planning. But this rebranding has done little to soften the stigma. If anything, it has made them seem more calculating. Imagine a lawyer sitting in a high-rise office in 2026, explaining to a 65-year-old woman why she needs to sue her husband for his medical disability benefits. The lawyer isn't shouting. They are whispering about equitable distribution and future security. This quiet, professionalized coldness is, for many, more terrifying than the loud courtroom theatrics of the past. The rise of eldercare litigation within the divorce framework has added a new layer to the stigma. Lawyers are now frequently involved in cases where the children are suing to prevent their parents' divorce. or where the divorce is being used as a strategic move to qualify for Medicaid. This is the Strategic Poverty Playbook. Step 1. File for divorce to split assets. Step 2. Transfer the majority of wealth to the healthy spouse. Step 3. The sick spouse applies for state-funded care as a single person with no assets. While this is often a desperate attempt by families to avoid being bankrupted by the American healthcare system, the divorce lawyer is the one who drafts the papers. They are the ones who manipulate the sacred contract of marriage for a balance sheet advantage. This has led to the perception of the divorce lawyer as a system gamer, who has no respect for the institutions of marriage or the state. The stigma was further reinforced by the high-profile divorces of tech titans and billionaires in the late 2010s and early 2020s. When the public saw Jeff Bezos or Bill Gates go through a divorce, they didn't see a tragedy. They saw a legal spectacle. The lawyers involved were making millions of dollars an hour to move numbers on a screen. This reinforced the historical trend that the law is not about justice, but about the high-speed reshuffling of capital. The average American struggling with their own household bills viewed these elite divorce lawyers as the high priests of a cult of greed. They were the ones who turned the end of a long-term partnership into a corporate merger in reverse. By 2026, the cumulative weight of these stigmas, the shyster, the bomber, the digital predator, and the silver vulture, has created a profession that is simultaneously more powerful and more loathed than ever before. But as the legal industry becomes more specialized and more expensive, a new resistance is forming. The public is no longer just complaining about divorce lawyers. They are actively working to bypass them. The rise of legal tech and AI-driven mediation is being marketed as the cure for the lawyer problem. However, as we move into the final chapters of this documentary, we must ask, is the lawyer really the cause of the misery, or just the mirror? If we remove the lawyer, do we remove the conflict, or do we just leave the vulnerable with no one to fight for them? The battle between the people and the bar is reaching a fever pitch. In the next part, we will explore the secret world of bar association lobbying and how the legal industry has fought, often tooth and nail, to prevent the very reforms that would end the stigma once and for all. How far will the industry go to protect its territory? And what happens when the lawyers themselves become the defendants? We'll dive into the world of legal malpractice and the suing the suer trend in the next part. Before we begin, a quick and important disclaimer. The content of this documentary is provided strictly for educational and entertainment purposes. It does not constitute legal advice, nor does it establish an attorney-client relationship between the creators and the viewers. The legal history and case studies discussed involve complex social, ethical, and jurisdictional shifts that vary significantly by state and era. Viewers are strongly encouraged to conduct their own due diligence and consult with a qualified legal professional regarding any personal legal matters or specific historical research. To understand why the stigma of the divorce lawyer has persisted into 2026, we must look at the invisible wall the legal profession built around itself to ensure its survival. For decades, the American public has asked a simple question: why is the process so complicated? The answer lies in the historical trends of bar association lobbying and the aggressive enforcement of unauthorized practice of law statutes. This is the era of the defensive monopoly. While the public viewed divorce lawyers as vultures, the lawyers viewed themselves as the thin line protecting the sanctity of the judicial process. However, the potential outcomes of this protectionism were often a system that remained intentionally opaque, expensive, and inaccessible to the average person without a high-priced guide. Imagine you are Elena, a paralegal in 2021 with 15 years of experience in family law. Elena realizes that 80% of the people walking into the courthouse are self-represented because they cannot afford the $5,000 retainers required by local firms. She decides to open a small office where she helps people fill out standardized forms, explains court procedures, and charges a flat fee of $200. She is not giving legal strategy. She is providing administrative clarity. Within 6 months, the State Bar Association files an injunction against her for the unauthorized practice of law. This case study isn't an anomaly. It is a step-by-step example of how the legal industry has historically used its power to crush low-cost competition. To the public, this looked like a cartel protecting its turf. The divorce lawyer wasn't just seen as someone who benefited from your misery. They were seen as the person who made sure you had no other choice but to pay them. Historical data from state legislatures across the United States shows that when bills are introduced to simplify divorce, such as creating administrative divorce for couples with no children and few assets, The most vocal opposition almost always comes from the matrimonial bar. They argue that protecting the client requires an attorney's oversight to prevent long-term tax errors or unfair distributions. While there is some merit to this, the public perception remains that the industry is lobbying against its own obsolescence. This reinforced the stigma of the divorce lawyer as a gatekeeper of the exits. They were the ones holding the keys to the door of freedom, and they weren't going to let you through unless you paid the toll. However, by 2026, the tide has turned in a way the industry never anticipated. The predator has become the prey. We are now seeing the rise of a phenomenon called suing the suer. As the stigma of the divorce lawyer grew, so did the lack of trust between the client and the attorney. This has led to family law becoming the most high-risk category for legal malpractice insurance in the country. Attorneys who once felt untouchable are now finding themselves on the other side of the deposition table, accused of the very same aggressive or negligent tactics they once used to win cases. Consider the case study of Marcus, a top-tier matrimonial attorney who in 2024 specialized in high-asset cases. Marcus was known for his killer instinct. In one particular case, he pushed for a scorched earth discovery process that cost his client, a tech executive, over $200,000 in legal fees. Marcus won the case, but the tech executive, looking at the final bill and the emotional wreckage of his relationship with his children, realized that the win was hollow. In 2026, Marcus is facing a massive malpractice lawsuit. Step 1. The client alleges a breach of fiduciary duty, claiming Marcus intentionally prolonged the litigation to inflate his fees. Step 2. The client's new legal team combs through every billable hour, every email, and every strategic decision Marcus made. Step 3. The expert witnesses testify that Marcus's tactics were not only unnecessary, but harmful to the client's long-term interests. This trend has created a new potential outcome for the profession: the era of the defensive practitioner. Divorce lawyers are now so afraid of being sued by their own clients that they spend a significant portion of the case papering the file. They send endless disclaimers, record every conversation, and refuse to give definitive advice. This has created a new layer of frustration for the American public. Now, the lawyer isn't just a vulture. They are a bureaucrat who is more concerned with their own liability than with their client's life. The historical trend has moved from the lawyer who would do anything to win to the lawyer who will do nothing that might get them sued. The data on legal malpractice in the 2020s shows that nearly 25% of all claims are now related to family law. This is a staggering number when compared to other fields like real estate or corporate law. The reason is the volatility of the emotional landscape. When a divorce goes poorly, the client needs someone to blame. The lawyer, who was once the knight in shining armor, quickly becomes the target. This has led to a cycle of mutual distrust. Lawyers now view their clients as potential litigants, and clients view their lawyers as potential scammers. This is the ultimate cost of the historical stigma: the complete breakdown of the attorney-client relationship. We must also examine the Bar Association disciplinary files that have become more public in recent years. These records reveal a step-by-step history of how the profession tried to police itself, and often failed. For years, minor ethical violations, such as overbilling or failing to communicate, were handled with a slap on the wrist. But in the age of 2026, where public transparency is demanded, state supreme courts are being forced to take a harder line. We are seeing more disbarments for financial misconduct in family law than ever before. This has given the public proof that the stigma was justified all along. The few bad apples are being used to define the entire barrel, and because the industry fought for so long to stay closed and private, it has no defense when the light is finally shown on its darkest corners. The shift in 2026 is also being driven by the consumer advocacy movement. Groups are now creating databases that track not just the lawyer's wins, but their conflict rate, how often their cases end up in trial versus mediation. The stigma of the bomber has become so toxic that a high trial rate is now seen as a red flag rather than a badge of honor. People are looking for the settler, the lawyer who can get them out of the system with the least amount of contact with the legal machine. But even as the industry tries to adapt, a larger threat is looming on the horizon. The very legal tech and AI-driven mediation that the bar associations tried to lobby against is now becoming sophisticated enough to handle complex assets and emotional nuances. The monopoly is cracking. The divorce lawyer is no longer just fighting a stigma. They are fighting for their economic life. The question is, If the lawyer is no longer the primary guide through the divorce process, what happens to the billions of dollars that currently flow through the industry? And more importantly, what happens when the human element of the law is replaced by an algorithm that has no concept of mercy or justice? In the next part, we will go inside the secret development of divorce AI, and how the next generation of legal technology is being designed to eliminate the lawyer entirely. We will examine the step-by-step process of how an algorithm can decide custody and split a 401k in seconds. But we will also look at the hidden dangers of a world where there is no one left to blame. If you take the lawyer out of the equation, does the stigma simply transfer to the machine? Or are we entering a new era where justice is just a series of data points? The battle for the future of the American family is moving from the courtroom to the server room, and the lawyers are preparing for their final stand. Before we begin, a quick and important disclaimer. The content of this documentary is provided strictly for educational and entertainment purposes. It does not constitute legal advice, nor does it establish an attorney-client relationship between the creators and the viewers. The legal history and case studies discussed involve complex social, ethical, and jurisdictional shifts that vary significantly by state and era. Viewers are strongly encouraged to conduct their own due diligence and consult with a qualified legal professional regarding any personal legal matters or specific historical research. The final stand of the traditional divorce lawyer is not happening in a courtroom with a mahogany bench and a stern-faced judge. It is happening in the glowing blue light of data centers in Northern Virginia and Silicon Valley. As we move through 2026, the historical stigma of the divorce lawyer has collided with the relentless efficiency of the digital revolution. For nearly a century, the lawyer was the gatekeeper because they held the secret knowledge of the law. But today, that knowledge has been commodified, quantified, and automated. This is the era of the algorithmic arbitrator, and it is the most significant threat to the legal profession since the invention of the billable hour. Imagine if you are Tyler, a 35-year-old manager at a logistics firm in 2026. Tyler and his spouse have decided to end their 10-year marriage. In 1996, Tyler would have been forced to hire a lawyer, pay a $5,000 retainer, and wait 18 months for a resolution. In 2026, Tyler opens an app on his phone called Neutral Ground AI. This is a step-by-step automated mediation platform that represents the culmination of a decade of legal tech evolution. Step 1 is the automated financial integration. Tyler and his spouse grant the app read-only access to their bank accounts, investment portfolios, and real estate records via secure APIs. Step 2 is the sentimental value analysis. The app asks each party to rank items of personal property, from the dining table to the digital photo library, on a scale of 1 to 10 based on emotional attachment. Step 3 is the generative settlement proposal. Within seconds, the AI uses game theory and historical trends from thousands of similar cases to generate a distribution of assets that maximizes the combined satisfaction of both parties. The potential outcomes of this technology are staggering. For the first time in American history, the cost of a divorce has dropped from the price of a mid-sized sedan to the price of a monthly streaming subscription. But this shift has created a new complex layer to the stigma. The divorce lawyer, once seen as a greedy predator, is now often portrayed as a desperate Luddite. As these AI platforms gain traction, the American Bar Association and various state bars launched a series of aggressive legal challenges. They argued that an algorithm cannot account for the nuance of human emotion or the specific best interests of a child. They claimed that the AI was engaging in the unauthorized practice of law. To the public, however, this didn't look like a pursuit of justice. It looked like an industry trying to maintain a monopoly on human misery. The historical trend of the lawyer as a gatekeeper reached its breaking point when the public realized the gate could be opened by a line of code. Consider the case study of the 2025 Florida legislative battle. A bill was introduced to allow AI-mediated settlements to be automatically entered as final judgments without the mandatory review of a human attorney. The matrimonial bar poured millions of dollars into lobbying efforts to kill the bill, arguing that the AI had a built-in bias toward the party who provided the most data. They cited potential outcomes where vulnerable spouses might be tricked by a machine that prioritizes efficiency over equity. While their concerns about algorithmic bias were statistically grounded, the public backlash was fierce. Social media was flooded with stories of people who had been bankrupted by human lawyers but saved by the machine. The divorce lawyer was once again the villain, but now the villainy was defined by a refusal to step aside for progress. Data from 2024 and 2025 shows that in jurisdictions where AI mediation is encouraged, the average time to reach a settlement has decreased by 75%. Furthermore, the rate of post-judgment litigation, where parties go back to court because they are unhappy with the result, has actually dropped. The theory is that people are more willing to accept a result from a neutral machine than from an aggressive opposing lawyer. This has led to the rise of the character of the machine. We used to talk about the honesty of a lawyer. Now we talk about the transparency of the source code. The stigma has shifted from the person to the process. However, the lawyers who have survived this transition are the ones who have undergone a radical rebranding. They have moved from being litigators to being AI whisperers or strategic overseers. In 2026, a high-end divorce lawyer doesn't write motions. They audit the AI's output. They look for the ghost in the machine, the subtle ways that the algorithm might be overlooking a complex tax consequence or a hidden offshore crypto wallet that the standard API couldn't detect. This has created a two-tiered system. The middle class uses the machine, while the ultra-wealthy hire a human guard to protect them from the machine. The stigma here is one of elitism. The divorce lawyer is now a luxury brand, a sign that you are wealthy enough to afford the human touch in an increasingly automated world. The step-by-step dismantling of the legal monopoly also involves the democratization of discovery. In the old days, a lawyer would charge hundreds of dollars an hour to review documents. Now, specialized discovery bots can scan 10,000 emails in 3 minutes, identifying every instance of financial inconsistency or conflicting statements. This technology has stripped away the lawyer's most profitable task, the grunt work. This has led to a historical trend of mid-sized family law firms collapsing, unable to sustain their overhead without the massive billable hours generated by manual discovery. The lawyers who remain are often solo practitioners who operate with almost no staff, using a suite of AI tools to do the work of a 20-person firm. But as the human lawyer fades into the background, we are beginning to see the hidden dangers of a world without them. A case study from late 2025 involving a digital custody heat map serves as a warning. An AI platform used the GPS data from both parents' phones to suggest a custody schedule that minimized travel time and maximized productive hours for the children. The schedule was mathematically perfect, but it was a human disaster. It failed to account for the fact that the father worked a night shift that wasn't reflected in his digital calendar, and the mother's free time was spent caring for an elderly relative. Without a human lawyer to interview the parties and present these analog realities to a judge, the family was trapped in a digital schedule that made their lives impossible. This brings us to the core of the 2026 debate. Has the removal of the lawyer actually removed the stigma, or has it just made the process colder? The historical stigma was based on the idea that the lawyer was an active agent of chaos. The machine, by contrast, is an agent of order. But order without empathy can be its own kind of cruelty. We are seeing a new historical trend where the public is starting to miss the very people they used to hate. When the machine makes a mistake, there is no one to yell at. There is no one to hold accountable. There is no one to plead your case to in the middle of the night. The divorce lawyer is currently in a state of professional purgatory. They are too expensive for the masses but too essential to be fully deleted. They are fighting to define what a human-in-the-loop legal system looks like. This battle is not just about money, it is about the moral high ground. For the first time in history, divorce lawyers are trying to claim that they are the defenders of the human spirit against the cold logic of the Silicon Valley giants. It is a shocking reversal of roles. The person who was once the homewrecker is now trying to be the home protector. As we look toward the final stages of this documentary, we have to face the ultimate question. What happens when the law is no longer a human conversation? If we successfully automate the end of a marriage, what does that say about how we value the beginning of one? The stigma of the divorce lawyer may be dying, but it is being replaced by something even more unsettling. The realization that our most intimate failures can be solved by a refresh button. But there is one thing the machine can never do. Can never take the blame. In the next part, we will explore the final taboo of the legal profession, the grief industrial complex. We will look at how the law handles the one thing that can't be digitized, the broken heart. How do lawyers, and now machines, put a price on the loss of a life partner? And why is the emotional settlement becoming the most litigated and most stigmatized part of the entire process? We'll dive into the world of emotional damages and the price of pain in the next part. Before we begin, a quick and important disclaimer. The content of this documentary is provided strictly for educational and entertainment purposes. It does not constitute legal advice, nor does it establish an attorney-client relationship between the creators and the viewers. The legal history and case studies discussed involve complex social, ethical, and jurisdictional shifts that vary significantly by state and era. Viewers are strongly encouraged to conduct their own due diligence and consult with a qualified legal professional regarding any personal legal matters or specific historical research. We have reached the most uncomfortable chapter in the history of the American legal system: the commodification of the broken heart. For decades, the law tried to stay out of the bedroom, focusing strictly on the math of bank accounts and the deeds to property. But as we move through 2026, we are witnessing the full maturation of the grief industrial complex. This is a world where the divorce lawyer has moved beyond the role of a financial liquidator and into the role of a psychological actuary. The historical stigma of the divorce lawyer as a vulture was rooted in their perceived greed for money. The modern stigma is rooted in their perceived greed for the very essence of human pain. We are now seeing the rise of hedonic damages in matrimonial law, a concept that attempts to place a cold, hard dollar value on the loss of the pleasure of life. Imagine if you are Sarah, a 55-year-old woman in 2026. You have spent the last 30 years as the chief operating officer of your home. You supported your husband through 3 career changes, raised 4 children, and managed the social capital that allowed him to ascend to the executive level. When the marriage ends, the traditional no-fault laws suggest a simple division of assets. But your lawyer, a specialist in marital tort litigation, argues that a simple split is a gross injustice. This is where the step-by-step emotional audit begins. Step 1 is the life path valuation. Your lawyer hires a forensic economist to calculate the opportunity cost of your 30 years. They don't just look at what you didn't earn. They calculate the compound interest of your lost identity. Step 2 is the relational equity assessment. The lawyer uses your digital history, 30 years of emails, holiday cards, and social media posts, to prove the value of the emotional labor you provided. Step 3 is the hedonic claim. The lawyer argues that because of the divorce, your capacity for future happiness has been diminished by a quantifiable percentage, and your ex-husband should pay for that loss in perpetuity. This historical trend of turning grief into a line item on a settlement sheet has led to a profound public revulsion. The divorce lawyer is no longer just seen as someone who splits the house. They are seen as a grief merchant. They are the professionals who tell you that your tears have a market price. This perception is backed by historical data from the early 21st century, when cases of intentional infliction of emotional distress, IIED, began to migrate from personal injury law into the family courts. While these claims were originally designed for extreme cases of abuse, by 2026, they have been refined into a standard tactical tool. The potential outcomes are clear. Every argument, every slight, and every moment of neglect is now a potential legal claim for damages. The technical execution of these claims involves a level of invasive scrutiny that would have been unthinkable 20 years ago. In 2026, we see the rise of the happiness economist. These are expert witnesses who use the Cantrell ladder, a metric for measuring subjective well-being, to testify in court about a client's internal state. Step 1. The economist administers a battery of psychological tests to the client. Step 2. They cross-reference the results with national averages for life satisfaction among divorced versus married individuals. Step 3. They apply a monetary conversion factor. If the client's life satisfaction has dropped by 2 points on a 10-point scale, the economist calculates the amount of wealth required to restore that satisfaction, often reaching into the millions. To the American public, this looks like the ultimate corruption of the human experience. It suggests that a high enough check can compensate for a wasted life, and the lawyer is the one taking a 30% cut of that compensation. Consider the case study of the Gray versus Gray litigation of 2024. This was a landmark case in which a wife sued her husband not for divorce, but for tortious interference with marital expectation. Her lawyers argued that his secret lifestyle had robbed her of the brand value of being a stable, married woman in her community. They conducted a reputational impact study, interviewing neighbors and local business owners to determine the exact drop in her social standing. The divorce lawyer in this case wasn't just litigating a breakup. They were litigating a brand failure. The stigma of this approach is immense. It portrays the lawyer as a person who views human relationships as nothing more than a series of business transactions and social contracts. Furthermore, we must look at the biometric data warfare that has become a staple of 2026 divorce proceedings. Lawyers now encourage clients to use their wearable health data as evidence of marital stress. Step 1. The lawyer subpoenas the spouse's smartwatch data from the last 3 years. Step 2. They highlight every cortisol spike and every night of interrupted sleep that occurred after an argument. Step 3. They present this as physical evidence of emotional trauma. The lawyer is no longer just listening to your story. They are using your biological markers to prove that your spouse was literally killing you. This has led to the perception of the divorce lawyer as a vampire of the psyche, someone who drains the most intimate biological data to fuel a legal battle. The data suggests that these aggressive emotional claims actually decrease the likelihood of a peaceful settlement. When a lawyer tells a client that their pain is worth $5 million, that client is far less likely to agree to a reasonable mediation. The historical trend of the victimhood narrative is a self-fulfilling prophecy. To win the case, the client must remain in a state of visible, documented trauma. If they start to heal, their damages go down. The lawyer, therefore, has a financial incentive to keep their client in a state of perpetual grief. This is the darkest side of the stigma. The belief that the divorce lawyer actively prevents healing because a happy client is a less profitable one. In 2026, we also see the emergence of legacy damages. This involves claiming that the divorce has caused intergenerational emotional harm to the children, which should be compensated through a massive increase in the settlement. Lawyers are hiring developmental actuaries to predict the future cost of therapy, lost productivity, and relational struggles for the children 20 years into the future. While the intent is ostensibly to protect the kids, the public sees it as a way to use children as human shields in a financial war. The lawyer is the strategist who designs this shield. The historical stigma of the divorce lawyer as a social pariah has reached its zenith here. We have moved from the gutter law of the 1940s to the soul law of the 2020s. The lawyer is no longer just handling the trash of a failed relationship. They are trying to put a price tag on the soul itself. This has created a profound crisis of identity for the profession. Many young lawyers are leaving the field, unable to handle the secondary trauma of managing such high-stakes emotional warfare. Those who remain are often the most hardened, reinforcing the public's belief that you have to be a monster to succeed in this business. But as the price of pain continues to rise, a final question remains. If we have successfully turned every human emotion into a legal claim, is there anything left of the marriage contract that is actually sacred? And as the lawyers push the boundaries of what the law can compensate, they are inadvertently inviting a total collapse of the system they rely on. The public is reaching a breaking point. The call for a maximum pain cap in divorce litigation is growing louder, and the very lawyers who pioneered these tactics are now finding themselves the targets of a massive legislative crackdown. But what happens when the state finally decides that the cost of divorce is too high for society to bear? In our final part, we will explore the end of the era of litigation. We will look at the radical new laws being proposed in 2027 that could eliminate the courtroom entirely, replacing it with a mandatory reconciliation or liquidated exit model. How will the divorce lawyer survive a world where they are no longer allowed to fight? And what is the final legacy of a profession that spent a century being the most hated in America? The conclusion of our masterclass will reveal the surprising future of the human heart in the hands of the law. Before we begin, a quick and important disclaimer. The content of this documentary is provided strictly for educational and entertainment purposes. It does not constitute legal advice, nor does it establish an attorney-client relationship between the creators and the viewers. The legal history and case studies discussed involve complex social, ethical, and jurisdictional shifts that vary significantly by state and era. Viewers are strongly encouraged to conduct their own due diligence and consult with a qualified legal professional regarding any personal legal matters or specific historical research. We have arrived at the final threshold of our journey through the shadow of the American legal system. As we stand in the current year 2026, the historical stigma of the divorce lawyer has not just transformed, it has reached a terminal velocity that is forcing a total collapse of the traditional matrimonial model. For 100 years, the divorce lawyer was the professional we love to hate, the necessary evil who navigated the ruins of our failed promises. But today, a radical new legislative movement is sweeping the United States, aiming to do what morality, religion, and digital technology couldn't: make the divorce lawyer obsolete. This is the era of the post-adversarial shift, and it represents the final legacy of a century of professional infamy. Imagine if you are James, a brilliant law student graduating in 2026. For the last 4 decades, a student with your grades would have been recruited by high-stakes matrimonial firms to become the next generation of bombers. But James looks at the historical trends and sees a graveyard of reputations. He sees the data on attorney mental health, where family law practitioners consistently rank at the top for burnout, depression, and substance abuse. He decides that the stigma is too heavy a price to pay. Instead of joining a firm, he joins a state-funded family resolution center. This is the step-by-step administrative exit that is currently replacing the courtroom. Step 1 of this new 2026 model is the mandatory triage. Under the newly proposed National Family Stability Act, couples are no longer allowed to run straight to an attorney to file a summons. Instead, they must enter a state-monitored portal that assesses the level of conflict. Step 2 is the algorithmic neutrality phase, where AI-driven tools perform the financial and custodial heavy lifting we explored previously. Step 3 is the mediator-only mandate. In many jurisdictions, lawyers are now legally barred from the initial 90 days of the process. They have been relegated to the role of technical consultants who are only brought in if the machine and the mediator fail. To the public, this isn't a loss of legal rights. It is a liberation from the predatory cycle of billable hours. The divorce lawyer's century-long reputation for inflating conflict has finally resulted in them being locked out of the room. The historical data from 2024 to 2026 shows a 40% decline in the number of students choosing to specialize in family law. The stigma has become a self-fulfilling prophecy of extinction. We have reached a potential outcome where the prestige of the divorce lawyer is so low that the field is experiencing a brain drain. This has led to the crisis of the complex case. While the state can handle the standard dissolution of a middle-class marriage, it is struggling with the truly high-conflict, high-asset cases that still require human nuance. But because society has spent 100 years branding these specialists as vultures, there are few good lawyers left to handle the mess. We must confront the scapegoat theory of the matrimonial bar. Historically, the United States used the divorce lawyer as a convenient repository for our collective guilt. We hated the lawyer because the lawyer was the one who had to tell us that our lifestyle was unsustainable, that our parenting was flawed, or that our assets were community property. By blaming the greedy lawyer, we avoided blaming the reality of our own choices. This is the mirror effect. The lawyer was simply the glass that reflected the most broken parts of the American domestic experience. In 2026, as we remove the lawyer from the equation, we are finding that the anger and the conflict don't disappear. They just find new, more chaotic targets. Consider the case study of the Seattle Reconciliation Pilot Program. In 2025, the city replaced its family court judges with a panel of resolutionists, a mix of social workers and accountants. The lawyers were gone, but the conflict metrics skyrocketed. Without a professional who understood the rules of war, the parties began to engage in unfiltered, unregulated psychological combat. They realized that the divorce lawyer, for all their faults, had acted as a heat shield. By absorbing the client's anger and channeling it through legal motions, the lawyer had actually prevented a significant amount of direct, face-to-face violence. The stigma of the bomber had masked the lawyer's role as the domestic peacekeeper. This leads us to the final assessment of the price of justice. The historical trend of the last century was toward making divorce easier and cheaper, but the unintended consequence was the commodification of the family. The divorce lawyer was the person who put the price tag on that commodification. As we look at the legacy of the profession in 2026, we see a group of people who were tasked with the impossible, to apply cold, objective laws to the hottest, most subjective human emotions. They were the janitors of the soul, and we hated them because they were covered in our own dirt. The final legacy of the divorce lawyer in America is a cautionary tale about the intersection of capitalism and the heart. We created a system where the only way to protect your interests was to hire a mercenary, and then we condemned the mercenary for taking the job. But as we move toward the 2030s, the vultures are fading into history. They are being replaced by the algorithmic arbitrators and the administrative clerks. The shyster of the 1940s and the bomber of the 1980s are becoming historical artifacts, like the traveling medicine man or the town crier. However, we must ask one final question. As the divorce lawyer vanishes, replaced by a sanitized, automated, and administrative process, have we actually fixed the problem? Or have we just removed the only human beings who were willing to descend into the gutter with us when our lives were falling apart? The stigma of the divorce lawyer was a shield that protected us from the terrifying reality that some things can't be fixed, and some losses can't be made whole. As the sun sets on the era of the high-conflict matrimonial attorney, we are entering a new, quieter world. But silence is not always peace. The battle for the American family is not over. It has just moved into a digital space where there is no one left to hear the screams, and no one left to blame for the bill. This concludes our deep dive masterclass on the historical stigma of the divorce lawyer. But while this documentary series is over, the evolution of the American legal system is just beginning. In our next major investigation, we will pivot from the end of the marriage to the birth of the next great legal frontier. What happens when the state begins to regulate the digital legacy of the deceased? Who owns your online identity when you are gone? And what new class of lawyers is waiting in the wings to profit from the data afterlife? The age of the digital estate predator is coming, and you won't want to miss the first part of that investigation.